So this video is something I've been wanting to have evidence on this kind of activity for 16 years now. When I went through the court system with my own battles, I saw the corruption firsthand in 2003 and 4. And I preserved a bit of it, but not like this. This is a Judge Lisa Gorcyca in Michigan who has had national attention before for her egregious actions on the bench. This is terrorism on the bench at the highest level. What's worse is that the Judicial Tenure Commission got involved and suggested a 30-day suspension without pay for Judge Gorcyca. And it went up to the Supreme Court, and the Supreme Court says, nah, we don't need to go that strong on her. So the Supreme Court of Michigan is totally against justice already. They've already shown that they have no intent, desire, or competence to hold their own accountable. This is the second time that Judge Gorcyca is going to be in the public eye now. The reason this time is just as disturbing, and when I show you the facts, as I have them now, I think you'll agree. Let's get started.
News right now, a judicial panel is recommending a 30-day unpaid suspension for Oakland County Judge Lisa Gorcyca. It's now up to the Michigan Supreme Court to accept or reject that punishment. The commission previously ruled that Gorcyca violated judicial conduct rules.
The judge who ordered 3 kids to juvenile detention for refusing to have lunch with their father is now facing accusations of misconduct. Let's bring in Steve Garagiola. He's live with more on the complaint that has been filed by the State Judicial Tenure Commission. Steve?
Yeah, so this is a big deal. You know, circuit court judges make controversial decisions all the time, so it's not uncommon that one side or the other is angry after pretty much every decision. That just goes with the job. But this is really something different. This is not so much about a decision that Judge Gorcyca made, but things that she said and did on her way to a decision. The 2-count complaint says Gorcyca failed to act in a dignified and courteous manner and made misrepresentations of law and fact.
Today, I ordered you to talk like parents that have 3 children are supposed to.
According to the complaint, the oldest child told Gorcyca he did not want to speak to his father because he believed the father was violent, having witnessed him hit the boy's mother. According to the complaint, Gorcyca told the boy, I ordered you to have a healthy relationship with your father. The court finds you in contempt. She had deputies handcuff the boy.
I don't know the facts of the case that Judge Gorcyca was previously censured on or punished on, but I do know this. If a child believes that a parent is an abuser and a judge can jail a child because the child is afraid to have a relationship, even after being ordered by a judge with that alleged abuser, then the judge is also an abuser. Lisa Gorcyca is a domestic violence abuser, and I am a mandatory reporter in this case. Judge Gorcyca instead increased the violence in this child's life and became a terrorist on the bench. The way that I got into this, a client came to me and wanted help with equal access to the courts due to a disability. So, Circuit Court of this county, Oakland, I went in and put in a request for reasonable modification to the designated responsible employee under Title II, which was apparently John Cooperrider. He's not an attorney. Usually they slap the label of ADA coordinator on the court administrator who is also an attorney. Doesn't appear that Mr. Cooperrider is very experienced in actually working out the details of ADA claims at all, and seems quite argumentative, but not adept at making equal access happen or a reality for someone with an invisible disability. That's been my experience with him anyway. And so I put in a request for reasonable modifications. There were about 12 modifications that I was asking for. And basically, I was asking for the judge to follow the law. The first thing I did during this hearing was it went on for quite a while, and it was obvious that the judge was not going to give me any kind of latitude as far as protecting the disability rights or equal access, or even to address those concerning the client's ADA rights, which are administrative, and I was there in an administrative capacity, not an at-law capacity. And yet I had requested to have my administrative remedy, and the judge had ignored it. So I was in a position where I needed to address that. So I opened up a chat window and I typed in the following. Let's see how that happened. So I'm going to kind of do a voiceover here on this. But right here, what's going on is I'm opening up a chat window and I'm typing in ADA rights are invoked, and they can hear me typing, and denial of access. Hang on. This staff attorney here, I'm sure they don't usually have a staff attorney around. They're watching me, but that's okay. Now watch. You can see her look at it. ADA rights are invoked and denial of access is affected. The client has ADA rights. There's a judge looking at it. Okay, seeing me type that in. Got a scowl on her face. So we got about 12 to 13 minutes into this hearing, and I finally got a spot where I could ask the judge an important question. Let's hear how that goes down.
Like, I want to hear from you, Mom. I want to hear from you, Dad.
Judge, may I ask why the client's ADA rights have not been honored and equal access has not been obtained?
What do you mean, sir?
I sent a notice off to Mr. Cooperwriter on 22nd,
What are you asking for?
invoking the ADA and asking for reasonable modification for...
Modification are you asking for?
It's in writing. Mr. Cooperwriter has it. He's the ADA coordinator, correct?
I'm orally asking you. What are you asking for? What modification?
Okay, to discuss the client's disability in front of the plaintiff is coercion and intimidation, and is forbidden by 42 U.S. Code 12203B. You're with notice. I've asked for a private, administrative, ex parte to discuss ADA access, and it has been denied so far. So I'm making notice of it on the record.
Thank you. Thank you, sir.
The very first thing I requested was that if Judge Gorcyca or any other judges involved with attending to this invocation or request, it is of paramount importance and reasonable modification is requested that any hearing or discussion on this disability matter be done ex parte as an administrative matter under Michigan Code of Judicial Conduct, Canon 3A, 4A. I even gave her her judicial canon that allowed her to do this and which she's supposed to go by. That wasn't done. There was no administrative ex parte, and so we went forward. So after this hearing, Mr. Cooperwriter, I had told him that I objected to him not answering the modification request. He told me I could appeal. We can't really appeal what hasn't been acted on. But I did appeal it, and the chief judge also sided with him, so I'm going to have to put in a JTC complaint on her as well because she's part of this shenanigans. The whole Circuit Court of Oakland is incompetent to deal with ADA requests for modification or compliance with the ADA. But he sent me this administrative order. It's a standing administrative order for the 6th Judicial Circuit Court, Oakland County Probate Court. So the Circuit Court Judicial, the administrative order is 2015-09J. And so it comes down here. It's talking about disabilities and how they're treated and so forth. Confidential means there will be no public disclosure by the court of the identity or disability of the applicant in any oral or written communications, including any files and documents submitted. That includes my request for modifications that I submitted by an applicant as part of the request process. Information will be shared only as necessary to review and process the request for accommodations. So they have it as a standing order since 2015 that confidentiality for disability is in place. It's not to be discussed in open court. So I have to say, this administrative order was basically a list, a laundry list, of how the Sixth Circuit Court of Oakland, and specifically Judge Lisa Gorcyca, not only screwed up in this case, but prejudiced the rights, the disability rights of this client irreparably, and still remains on the bench in this case. After I had let her know and let the Judicial Tenure Commission know that a reasonable person would not expect an impartial adjudicator after a judge had prejudiced a case so horribly by, look at this right here, D, this is on this same order. The court will maintain the request in a separate confidential administrative file, so as not to reveal the applicant's identity or the information contained in the request. And yet she asked me to publicly disclose this, what was in the request. Correct?
I'm orally asking you, what are you asking for? What modification?
Okay, to discuss the client's disability in front of the plaintiff is coercion and intimidation and is forbidden by 42 U.S. Code 12203B. You're with notice. I've asked for a private, administrative, ex parte to discuss ADA access, and it has been denied so far. So I'm making notice of it on the record.
Thank you. Thank you, sir.
So on the same day, I filled out and sent off overnight a request for investigation form to the Michigan Judicial Tenure Commission. Judicial Tenure Commission wrote me back, and this is March 5th, it's just recently. Dear Mr. Shore, the Judicial Tenure Commission acknowledges receipt of your request for investigation. The Judicial Tenure Commission has recommended punishment before for Lisa Gorcyca. And when it went up to the Supreme Court protected its own, just like is usual and customary. So how did I get into this? I looked, and I looked, and I looked, and I looked some more for someone who would champion the cause of the common man and woman, the common person, who goes into court with a disability, an invisible disability, and help them get equal access. And I found that person not in a lawyer, but in Dr. Karen Huffer, who was my trainer, mentor, and friend. She passed away in 2018, and I'm carrying her torch forward. I'm a certified Americans with Disabilities Act advocate for litigants with invisible disabilities. And I'm here to tell you that the emperor has no clothes. Judicial immunity is a failed system. If judges can harm people with impunity and not be held accountable when the law requires them to provide equal access, we don't have a justice system. The real reason I'm here is because lawyers are afraid to take on judges and hold them accountable. Don't take my word for it. Hear it from the lawyer who writes the book for the American Bar Association called Understanding the ADA. The author that I talked with on the phone, that I spoke with on the phone, is William D. Gorin, and he is an attorney that has written the book that the American Bar Association sells called Understanding the ADA. Now, this is his 4th edition, and this guy's an expert. He spent 23 years practicing the Americans with Disabilities Act field. He's a founder and current president of the National Association of Attorneys with Disabilities. So this guy, if there ever was an expert on how the ADA works, this guy is the guy. And I want you to hear what he says about how access really works.
So what are you looking for from me? I'm not sure I'm the best fit as much as I'd like to help, but I'm not sure I'm the best fit.
Can you
what are you looking for?
Who do I go to hold these judges accountable so that they have to give accommodations?
So you're looking for someone who's not afraid that, you're looking for a litigator that's willing to go in and take on state court systems?
There you go.
The problem that attorneys have is a lot of attorneys won't take this on because the court will fight back hard and threaten disbarment and other kinds of proceedings. So a lot of attorneys are scared to take this stuff on.
Sure.
We do not have recourse. We do not have access. Why am I here? Because, as you heard Bill Gorin say, lawyers are afraid to take on judges because of threats of disbarment and other proceedings. And when the Judicial Tenure Commission of Michigan can recommend a punishment for a judge, which is very rare, and the Supreme Court can override that and allow the judge to continue abusing people because it shows leniency and favoritism and protection, there is no justice.
No. So you feel that because of what she did on February 24th, that the judge should recuse herself from this case and have another judge listen to the case?
A reasonable person would not expect an impartial adjudicator if someone cannot gain equal access as a disabled person to the court.
Okay. So there's a Zoom link when you're on that Zoom. Arguably you could record it because we're one party state, but
The Circuit Court Administrative Order 2015-09J, it says that there will be no public disclosure by the court of the identity or disability of the applicant.
I 100% agree with you. The judge was wrong when she did that. I 100% agree with you. 100%.
After I exposed the Judicial Tenure Commission representative's words saying that she had actually done wrong, Judge Gorcyca chose to recuse herself from the case. That's what judges do. They run. And what I'm waiting for is the opportunity to go into federal court and sue these judges so that they can have their asses spanked for discriminating so blatantly. That's what I'm waiting for. But this judge at least ran.